All right, the next matter to come before the court is Amherst Marketplace Station LLC versus Amherst Exempted Village School Board of Education and Lorain Board of Revision and Lorain County Auditors. To the appellants, you will jointly, to the appellees, you will jointly have 15 minutes. Will you both be arguing? And if so, who's going first and how are you splitting your time?
I don't know that it matters who goes first. I can certainly go if Attorney Stedronsky is okay with that, but we had intended to split the time equally.
That's correct, and she can go first. That's fine.
All right. All right, each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, let me know when you begin your argument, and I'll do my best to keep track and keep you apprised of when you're approaching your rebuttal time. These arguments are being visually and audibly recorded. They are being live streamed as we speak. We have read your briefs and ready to proceed when you are. Mr. Byrne.
Yes, may I please record, my name is Jeff Byrne on behalf of Amherst Marketplace 3. The key issue in this appeal is that the Board of Tax Appeals held that the appraiser or evaluation of property may appraise or value the unencumbered fee simple estate pursuant to revised code 5713.03 as if it were leased at the time of sale. The key issue in this case is similar to a case that is currently pending before the Supreme Court. It's called Rancho Cincinnati Rivers versus Warren County Board of Revision. That's case number 2020-0643. The 9th District here perhaps might want to hold a decision on this case pending the outcome of that case. Basically, the overarching issue in this appeal is that the Board of Tax Appeals feels that the directive of the statute that says property must be valued in the fee simple estate as if unencumbered somehow means that the property can be valued as encumbered by a lease at the time of sale. There's nothing in the legislative text of 5713.03 as revised that says property can be valued at least at market rates, as the Board of Tax Appeals says. There's nothing in the legislative history that makes that clear. And finally, you have a decision of the Ohio Supreme Court in the case known as Lowe's 2 in the briefs, where the court said it is plain that a lease is an encumbrance, and revised code 5713.03's directive is to value the realty as if it were free of encumbrances such as leases. Obviously, a property that is leased, even leased at market rates, is not free of lease encumbrances. So the particulars in this case, here the Board of Tax Appeals accepted a recent sale of the property as evidence of the property's value. The property was clearly encumbered by leases at the time of sale. The Toronto 8 decision mentioned in the brief states that the BTA must now consider evidence of unencumbered value even when there is a sale of the property, a sale of the property where the property was encumbered by leases at the time of sale. The BTA decision takes an enormous amount of time and space talking about the fact that Amherst Marketplace didn't reflect the arms-like nature or recency of the sale. This is basically a red herring because Amherst Marketplace didn't challenge the recency or the arms-like nature of the sale. What Amherst Marketplace was arguing was that the sale of the property was a sale encumbered by leases, and it did not reflect the unencumbered value of the property as of January 1st, 2017. In upholding the sale price, the BTA makes the determination that the sale represented the best evidence of the subject property's value because the leases that were in place at the time of sale were, quote, consistent with the market. This is the clear reversible error in this case. Revised Code 5713.03 says property should be valued as if unencumbered. Revised Code 5713.03 does not say that property shall be valued as encumbered with leases consistent with the market. In fact, in the Taraz 8 decision, the Supreme Court plainly said Revised Code 5713.03 does not now require an inquiry into whether a lease in place reflects market rent at the time of sale. This is because valuation is to be as if unencumbered. A lease is an encumbrance, and the Lowe's 2 court said the property must be valued free of lease encumbrances. Amherst Marketplace is asking that the court direct the BTA to find unencumbered value, not value as encumbered with a lease consistent with the market in the BTA's mind.
Counsel, would you agree that the best evidence rule of property valuation remains a recent sale of property, but it could be rebutted by additional evidence? I mean, the amendment to the statute did not change that general rule of law, did it?
Sure, and the Supreme Court has said that that didn't change the traditional rule of best evidence. But when there's rebuttal evidence of unencumbered value, the BTA has to find the best evidence of the property's unencumbered value. The BTA cannot, as a matter of law, find the best evidence of the property's encumbered value consistent with the market. And that's what the BTA did here.
So in your case, you used RASIC's appraisal as rebuttal.
Yes.
What other evidence, if any, is in the record to rebut the presumption that the sale price reflected the true value?
That's the only evidence that was presented by Amherst Marketplace.
Thank you.
And then the BTA has to have some evidence to support its findings. And here, the BTA found that the Giant Eagle lease, which is the majority of the shopping center here, was at market. The finding that the Giant Eagle lease specifically was at market is also reversible error in this case. The BTA relied on to make the conclusion that the Giant Eagle lease was consistent with the market. They relied on the appraisal report by Thomas Sprout presented by the county. There are a number of issues with Sprout's valuation of the property. Sprout's highest and best use, which an appraiser uses to provide a roadmap for an appraisal, stated that his highest and best use was occupied primarily by a regional retailer. Obviously, Giant Eagle is a regional retailer. That was Sprout's signal that he valued the property as leased to Giant Eagle because it was in fact leased to Giant Eagle. I'm going to quote Sprout here. He said, starting on page 38, I've included other properties that I thought would be consistent with the subject. The subject that is a Giant Eagle, it is not vacant. Later, he says, if the property was vacant or if there was a different tenant in the property, and then he stops, he says, I take that back. That's not part of my conclusion. As we stated in the brief, that's basically a Freudian slip for him. He's valuing the property as leased to Giant Eagle because it is leased to Giant Eagle. The Giant Eagle lease at the subject property was negotiated in 1996 as part of the construction of the property. It's called a build-to-suit lease. That's where the potential tenant, and the developer enter into agreement that says the developer will pay X amount of dollars to construct this building to your specifications, and the lease rate that gets paid is commensurate with the cost of construction. It's basically amortizing the cost of construction by the tenant's specifications. The BTA's duty was to find value of the property as of January 1st, 2017. That means that the BTA needed to determine what would be the market rent for an existing building that's 20 years old as of January 1st, 2017. And what what someone paid to construct a brand new building in 1996 does not tell you what the property would lease for as of January 1st, 2017. And that's a big difference between the Sprout comparables, which were all build-to-suit leases, and the RASIC rent comparables, which were all landlord has available space, tenant is looking for available space, and they come to an agreement on what market rent is. And this is a legal question. A build-to-suit lease from decades prior cannot, as a matter of law, reflect what an existing building would lease for as of the assessment date at issue. And with that, I would like to reserve the rest of my time for rebuttal.
Judge, does he have additional time on his 15? Can you tell me how this how this is different than Terraza, the decision in Terraza, which also involved, well, you know the case. How does this case differ from Terraza?
The Terraza decision was the first Supreme Court case involving the sale of a property where the property owner tried to rebut that with evidence of unencumbered value. And the BTA there found that the sale price was the best evidence of value and didn't even consider the appraisal evidence. And then the case was remanded back to the BTA, and the BTA actually there found in favor of the owner's appraisal report. But since that time, the BTA has, in this case and in a couple other cases, found that the sale price is still the best evidence of value because the leases in place at the time of sale were consistent with the market. It's different in that regard because of that holding. The BTA has sort of staked its claim on this leased at market theory that is wholly inconsistent with the plain language of Revised Code 5713.03 and the Supreme Court's decision in the case known as Lowe's 2 that the property must be valued as if free of lease encumbrances.
Thank you.
Ms. Finnegan, whenever you're ready.
Thank you, and may it please the court. My name is Kara Finnegan, and I represent the Lorain County Board of Revision and Lorain County Auditor's Office in this matter. I guess the county views the BTA's decision here a little differently than the things Mr. Byrne has already spoke about this morning. So he talked a lot about the appraisal evidence, and I think mostly what the BTA's decision in this case was addressing the sale price. So the conveyance fee statement, which indicated the amount of consideration for real property, did list initially that that sale price, fair market value of $11,655,000, which is what the BOR below had set as the value for 2017. At that point, it's a very low burden once there's evidence of a recent arm's length transaction, and as I think Judge Teodosio pointed out earlier, that recent arm's length transaction or recent arm's length sale still remains the best evidence of value, even if there is a lease in place at the time. At that point, the burden shifts, and at that point, it's the property owner's burden to show that sale price should not be used and does not reflect the fair market value of the property at issue. And in this case, I think the BTA certainly did what they were supposed to do, and other evidence is presented besides just a recent sale. They looked at both appraisals. The opinion is very lengthy in discussing those appraisals, the pros and cons, and ultimately they didn't go with either appraisal. I think what they are saying in their decision is kind of going back to a Spirit Master case earlier, that appraisal evidence can either rebut or can also essentially validate a sale price. And here they felt that Sprout's appraisal would have basically just was further evidence that that sale price was a correct price for fair market value. And I think the BTA's point here was that the property owner was in the best position to show us what that lease really meant to the buyer at the time, what they valued that at, and what percentage of that price was paid for the tenant in place, the lease in place. None of that evidence was presented, and I think the BTA pointed out some concern of just taking Mr. Rasick's appraisal at face value and interpreting that as that was the value of the property versus the value of the lease, which would have then been, I believe his appraisal came in at $4,730,000, which would have left a remaining nearly $7 million to be the value of that lease in place. I think the BTA was very uncomfortable in assuming that without other evidence of perhaps the motivations of the parties, what the parties felt that that lease was worth to them. And so in doing that, considering the appraisal evidence, the evidence of the recent sale, they felt that there was more evidence there to adopt the sale price, and that they felt that, as the county feels, that the property owner did not meet their burden in showing that that was not a fair market value for the property. And getting to the appraisals, the issue that the county has with Mr. Rasick's appraisal is that he's looking to value the property as though it were vacant. And the county does not believe that that's a proper reading of the statute. It doesn't, the property was not vacant at the time of the tax lien date. It was an operating regional tenant. And I think it's not uncommon to see an appraiser say, these are the properties, these are the comparables here that are comparable to our subject property. And in looking at that, Mr. Sprout saw that this giant eagle, essentially the anchor tenant, was occupying about 95% of the subject property. Given that, he felt it would be a better method for him to look at similar properties, mostly single tenant users felt that that was going to be an easier way to go about it than looking, as Mr. Rasick did, towards these very large multi-tenant retail shopping centers, which were not very reflective of what the subject is. The subject is one large giant eagle tenant, two inline spaces, and a gas and convenience store, a Giant Eagle Get-Go, that's also on the property. So in looking at that, looking at retailers that have, 10, 12, 20, inline retail spaces is not comparable to the subject. And as such, he did not find those to be good units of measurement in coming to his value conclusion. And I think that's exactly what the BTA saw here as well, that these comparable properties that were vacant or much larger were not a good measuring stick for this particular property. And I think additionally, I'm sorry, give me 1 second. Oh, additionally, I think looking at this as for second generation users, that's not what we have here. This is not a second generation user. This is a Giant Eagle that was in there at the time of the tax lien date, was operating. So what Mr. Sprout did was look at that as, still its highest and best use was still for that purpose. There is no reason that should change. And in doing so, he looked at those similar properties and adjusted for any lease encumbrances or any other encumbrances that the property might have to come to a fee simple value. And I think in contrast, Mr. Rasick was looking at this as reading the statute to be that the property must be valued as vacant, and that leads to it leads to a value conclusion that is not proper. So it's the court has said that in the Lowe's case is a different Lowe's case as well, that appraisers are not needing to value properties as vacant. That's not what the statute is looking for. And here, I think really they considered the appraisals. They found that neither of the appraisals rebutted the sale price, and based on that, adopted the sale price, finding it to be the best evidence of value here, and the county would agree with that. And with that, I will yield my time as I've gone a couple seconds over.
Just one quick question. Do you agree that the case currently pending before the Ohio Supreme Court is controlling on this?
I'm only laughing because that was my question too.
Oh.
You know, I don't know if it's, I mean, certainly if the Supreme Court issues a decision, I would assume that would be controlling law, yes. You know,
I mean,
but
exactly the same.
I'm sorry?
Go ahead, Judge.
I think he wants to know, do you agree that the issue before the Supreme Court is the same issue?
I don't agree that it's the same issue, because I think that's dealing more with how to value, if I'm correct. I'm sorry, I'm not totally up to date on that case, but my understanding from what I know is that has more to do with appraisal technique, or what, you know, what is a correct way to appraise the property based on what the statute says. I think here we have, was the sale rebutted? And I don't believe that the property owner or the appellant in this case met that burden.
Thank you.
All right. Mr. Stedronsky, you can unmute and proceed.
Thank you. May it please the court. My name is Gary Stedronsky, and I'm the attorney for the Board of Education of the Amherst Exempted Village School District. Also, as an aside, graduated from there, so proud graduate as well. But anyway, this case to me is a basic case. I wrote a 30-page brief on it. I don't want to reiterate all of that for you, but I say it's basic despite there being 17 assignments of error, because we have a sale here. They tried to rebut the sale price. The BTA did not buy the Rick Rasick appraisal report, and they fully explained in an 11-page decision why they didn't. And so they rejected that and accepted the sale price, just as Terraza says you should do. That decision was reasonable and lawful. It should be upheld. Their argument would be more believable as well if their own handpicked expert witness went along with their argument. And what I mean there is he himself did a sales comparison approach with properties that were leased. He adjusted those leases down to market rents in his mind. He also did an income approach, which if you adopt their argument, an income approach is wholly inconsistent with their argument. The income would be zero if you assume a property has no lease. The expenses would be great. You still have to pay taxes and other things. And the value would be zero when an appraiser does an income approach. So to say you can't appraise property at market rental rates is crazy. They don't take their argument the step further that they need to. They just say, you can't, the statute says you can't appraise it at market rents, and you have to assume that it's vacant or unleased. But they don't tell you what that means. But what that means is that an income approach can never be used anymore. And their own appraiser used an income approach, and he said, here are what I think market rates are. Despite never submitting a copy of the lease, he said, the actual lease here, the rate is way higher than what I believe actual market rent rates are, to the tune of a value of $7 million, and that you need to discount the sale price by $7 million. And the BTA saw right through what they were doing. The BTA also noted that no witness for the actual property owner testified as to the circumstances of the sale or as to how that lease impacted the sale. And the only evidence was the Rasick appraisal report, as Mr. Byrne noted. They never submitted the lease. Mr. Sprout noted that he found a mortgage that indicates that a bank would have believed this thing was valued at least at $9 million. And so the BTA saw what they saw through what they were arguing. It properly applied the Terraza decision and held that they simply failed to rebut the use of the sale price. And Ms. Finnegan explained some of the reasons why. It's basically that Rasic was comparing apples to oranges. So he's comparing a thriving property to properties where the first generation user has left for whatever reason, and they're then rented to second generation users. Often those second generation users, when the property owner or the tenant leaves, because it's a build to suit lease, there might be things in there saying that you can't release it to a grocery store, you can't release it to a retailer store like a Home Depot or Lowe's. So there's often in the second generation type comps, you see restrictions where the potential best user of that property is excluded because the prior users and owners have said, we're not going to release it to a competitor of yours. So he said, Rasic said, the best evidence are these second generation comps, and the county presented Mr. Sprout's appraisal, who said, well, look, this is still a first generation property. It's not yet gone dark, gone vacant, and been released. Why would we treat it as such? And so his comparables are more like Giant Eagles, Kroger's, Home Depot, and properties like that, rather than Papa John's and Mark's. So, as I said in the brief, I think a casual observer could see that his comparables were far more similar to what this property actually is. So what Rasic was trying to do was to remove in his mind what the effect of the lease, the actual lease, and that encumbrance was upon the property. The BTA simply didn't buy it. To their argument of you must assume that a property is unleased, I cited what I called a mountain of case law in the brief. I still believe it as such that indicates that you can appraise property, even property that is owner occupied. So the Steak and Shake case, the Harrah's case, which is a casino that was owner occupied, the Supreme Court has said you can appraise those owner occupied properties by looking at what would they rent for in the market. And then we take that market rental rate, subtract expenses, you come to a net operating income, and then they apply what they call a cap rate, and that's how you derive value. And so there's at least 4 cases that I cited where that was allowed for even owner-occupied property. This here is not owner-occupied property. It is, in fact, leased. So clearly you can assume market rental rates and then derive a value. That's what both appraisers claimed they did. The BTA found that the actual lease in place was at market. And so basically they're saying if the property was vacant and available to be leased, it would lease for the exact same amount that the current lease exists for. And so that's what they're saying in effect.
Counsel, I have a question. There seems to be a whole lot of information about the lease that the Board of Tax Appeals said is unfortunately not in the record, or was not submitted by the appellant. I'm just wondering, was it? I'm gathering, even though that neither appraisal was used as the true and best value, did the reports of the appraisers in this case contain a copy of the lease? How is it we have so much information in the record about the lease that we, don't have?
The only thing in the appraisal reports that dealt with the lease were really the rental rates that were in place. And so you couldn't see, and we have no idea whether or not, this property was built in 1996, so a long time ago. So is this still under its first term? We have no idea. Is it under a renewal term? Meaning 3 years ago, did Giant Eagle have the option to leave, but the lease provided that, well, you can stay if you pay us this rental rate. We have no idea about that. So all the property owner's appraiser did was summarize the lease rates in the appraisal. But in terms of the actual details of the lease, its original length, the renewal terms, where was it in the renewal term as of the tax lien date? We don't have that information. And so I think that's what the BTA was concerned about not having. It's not in the county or Board of Education's possession. It's in the property owner's possession. So, basically, what are you hiding and why didn't you present it?
Thank you.
Right?
Counsel, I would also like your view as to the impact of the case currently pending before the Ohio Supreme Court on this case.
So I have not heard about that case before. I don't know when the Supreme Court accepted cert in that case. It wasn't mentioned in any of the briefs or a supplement to a brief in this case, unless I missed it. So I just can't comment on it without knowing the facts of that case.
All right, thank you.
Thank you. That's probably my time. So
That was exactly your time. Thank you.
Thank you.
All right. Mr. Byrne? Yeah, you're going to have to get off mute and then go ahead and proceed.
Thank you, Your Honor. I think with what you saw with the county and Board of Education's arguments were a desire to avoid the ultimate question in this case. They wanted it to say, oh, it's a simple case. BTA just upheld the sale. They didn't think the appraisal evidence rebutted it. But the court should look to what the BTA said. They said that the sale was consistent with the market, and that's why they upheld the sale as the true value of the property. I don't think in the briefs or in the argument here, we have no argument from the appellees that directly answers the question of how a property can sell as if unencumbered and still encumbered by a lease consistent with the market, quote unquote. There was a lot of talk about the actual lease in place at the sale. Amherst Marketplace wasn't hiding anything in terms of the lease of the property. The lease rate was well known between the two appraisers. You can look at the lease rate, you can look at what the price was paid for the property, and you can come up with a capitalization rate that was paid as part of the sale of the property. If Amherst Marketplace were to introduce as a witness the parties to the sale, they're going to say, yeah, of course we paid what we paid for the property because of the lease in place. That's what a real estate investor does for leased property. There's basically two types of real estate investors. One who pays a passive investor who looks for in-place income stream from a lease, and one who looks for entrepreneurial value add for a property that's currently unencumbered by a lease. The law says that the property must be valued as if unencumbered. And so how do we prove the unencumbered value when we know the as encumbered value of the property? We go to the market. And that's what we did with an appraisal. We say, okay, this is what the property sold for as encumbered by a lease. Here's what the markets would say what the property would sell if it were to sell as if unencumbered. And I think it was very telling in some of the comments made by counsel for the county and the Board of Education. They kept talking about, well, this property is a giant eagle. This property is still operating as a giant eagle. It's a successful property. That's clearly a value in use, and it's clearly against the plain language of the statute. The statute says as if unencumbered. As if is a hypothetical. It doesn't say if the property is currently occupied and operating as a first generation tenant, you appraise the property as occupied by a first generation tenant. Conversely, if the property is unencumbered, you appraise it as unencumbered. The property says all property as if unencumbered. And I think it's telling with what the BTA's decision, Sprout appraisal, and then the arguments from the appellees that they're doing everything in their power to avoid the ultimate question of the statute. We're asking that the statute be upheld. A comment from Attorney Stadronsky about the income approach to value. The income approach is possible in an unencumbered valuation, and I think if the court looks to our brief and the comments about the Harris casino decision, wherein the Supreme Court said that the possibility, quote, possibility that the property could be encumbered by a lease after purchase could be assumed in an unencumbered valuation. That Supreme Court decision also quoted the appraisal of real estate, which states when the fee simple interest is to be valued, the property is assumed to be available to be leased at market rate. So investor can buy a property, then encumber it by a lease. And there you can look at, well, what could they get for their property? What could they lease their property for on January 1st, 2017? That would influence the market rent, would influence the capitalization rate under an income approach to value. And then finally, in terms of the myriad of cases mentioned by Mr. Struganski, I think you'll see multiple cases, especially the stake and stake case, where the Supreme Court has clearly stated that unencumbered value and encumbered value are different for tax assessment purposes, and that needs to be reflected in assessments. Thank you.
Perfect timing. All right, thank you all for your arguments. We will take the matter under advisement, issue our written decision in due course. It'll be posted on our website as well as that of the Supreme Court. The next video arguments